So this is our final topic for this unit, and I'm going to start with the sentencing goals of corrections. We have 6 sentencing goals, which are a little different than the justifications that we've used in the past. The sentencing goals, of course, start with punishment, and that's punishment for the sake of punishment. You did something wrong, so you must be punished. The second one is retribution, and that's kind of justice for the victim or the victim's family, that they deserve retribution. The third one is deterrence, and we have 2 types of deterrence. We have specific deterrence and general deterrence. So specific deterrence is, okay, you did something wrong. And what I'm going to do is make the punishment so harsh that you don't ever want to do that thing wrong again because you don't want the punishment. That's specific to you. General deterrence is, you did something wrong, and I'm going to make the punishment so harsh that everybody else looks at you and goes, I don't want to do that offense, that crime, because that punishment stunk, and I don't want that. So it's basically like using you to set an example for everybody else. And so that's general deterrence. The fourth goal would be incapacitation. Obviously, if you are incarcerated, that's going to reduce your ability to commit crime. Not that we don't have crimes occurring within the prisons and jails and probation and parole, but it does help limit that, and it definitely limits the victim population. The fifth one is rehabilitation. Um, Today's society, we sometimes say, we focus too much on rehabilitation and I don't care about rehabilitation. But the reality is, these people are going to be back out in society, and we need to address that in some way. I don't know about you, but if there's some way, take especially young offenders, um, if we can provide them with a different opportunity, job skills, training, things that can help them survive on the outside and become productive members of society, that's so much better than continuously having them in the system. And then the final one is restitution, and that's where they repay society or the victim for their wrongs. Please note that restitution is completely different from fines that you pay. Restitution is to the victim or to society. So, those are our major sentencing goals and why we have the correctional system that we have. A couple of key things you need to know about where we work now. We have selective incapacitation, and that's longer sentences based on what we expect an offender to do, not what they've already done. So, I wonder how you feel about this. Do you think that that's unconstitutional to lock somebody up longer, to incarcerate them based on what we think they might do, not on what they've already done? It's slightly offensive, but let me give you an example of where that comes into play. One of the key things that pops to mind is child molesters. We lock them up longer than, if you are a child molester, you'll do more time than if you were a murderer. And the reason for that, the mindset behind that, is that most people murder once. Very few people actually go out and kill somebody again. Um, but a child molester, they have a really high rate of recidivism. So it's more likely that they're going to reoffend, so we lock them up longer. And, there's a lot of debate about the constitutionality of that. In some states, they have the ability to, once a sex offender has completed their sentence, all right, um, they've gone through, done their prison time, they can then be involuntarily committed for a mental illness and institutionalized that way. And so they kind of stay under supervision. And I'm interested to see how that comes out with the Supreme Court, because that does seem like double, being punished twice, double jeopardy. So it'll be interesting to see what that goes. I use the term recidivism, and that's really relevant in corrections. It's when an offender completes their punishment and they reoffend. And we can kind of judge the effectiveness of what we're doing by the recidivism rate. If our goal is to, obviously deter someone from committing that crime again. And so you get in trouble for this, we lock you up, you do 3 months, you get out and you immediately reoffend, then we didn't have the right level of deterrence because the recidivism continues. And that's obviously something that we struggle with in the corrections system. So, sentencing, our official definition of sentencing, is the imposition of a criminal sanction by a judicial authority. While it's a complicated process, it's important that we understand it because if you're going to work in the correctional facilities, you need to know how people end up where they are and how that works. But also on the other side, if you're going to be in law enforcement or the court system, you need to understand the implications of all these individual processes. Once a criminal has been found guilty or has pled guilty, a judge must determine the sentence. Now, in some places, a jury has say-so in that, but usually it's a judge. So let's look at the functions of corrections and where we stand. We have a couple of pre-trial functions. This is what corrections does before a person is ever found guilty. The first one is diversion from the CJ system. This is when they're allowed to participate in treatment programs and avoid criminal behavior and criminal sanctions by suspending that processing. If they complete everything that they're supposed to, those charges are dropped. This could be, usually what comes to mind for me are juveniles. Juvenile gets arrested, we say, okay, if you do so many hours at this volunteer organization, or you complete this class, or, different stipulations, and you don't get in any more trouble, in 6 months, when you've done all of this, we'll drop the charges. Now you might say, well, what's the point of that? Well, once you're labeled a criminal, it's much more challenging to find a job, to get funding for college, scholarships, even federal financial aid is often linked to criminal background. So if we can avoid that, we're providing more opportunity and the opportunity for a future for these offenders. And there's a lot of advantages to that. It also means and the places where I see this is usually like underage drinking, possession of marijuana, something like that. If we can get them into a facility at their own expense or their parents' expense, it's less burden on the taxpayers, and they're getting help for something that wasn't a violent crime. The second pretrial function is pretrial detention. That's after arrest, booking, and being read the charges, offenders can be held until trial. And this is what we're pretty familiar with. This is when you sit in jail until you go to court. And this is done to prevent flight, so keep people from running away and not facing the consequences. The third one is release from pretrial detention on bail. And that's a pledge of property or money in exchange for the promise that a person's going to show up. So I'm going to put a certain amount of money down, and that's going to guarantee that I show up because I don't want to lose that money. You do actually get the money back if you show up and everything's done. And it's important to note that the Eighth Amendment guarantees the right against excessive bail, but it does not guarantee your right to bail. So someone who we think is violent or a flight risk, they're not going to be granted bail. We're pretty familiar with bondsmen, and that's where you put up a percentage, usually 10% of your bail. If your bail's $2,000, you put up $200, and he actually covers you for the $2,000. Now you don't get your $200 back, and if you don't show up, he wants his money, his $2,000. So the bondsman often comes and finds you. It's where we hear about bounty hunters. Alternatives to bail, which would be our fourth pretrial service, would be personal recognizance, unsecured bond, percentage bond, surety bond, third-party custody. Particularly with juveniles, you might be released into parental custody. So those are some alternatives. And the fifth one is pretrial service programs. And usually this is you're released on your own recognizance, so you're released into your own care on the agreement that you will appear. But it might be that you're released so that you can, go to some kind of treatment program or something like that. The Manhattan Bail Project started in the 60s to assist judges in identifying individuals who were good candidates to be released on their own recognizance. The problem we had is bail couldn't be excessive, but for some people, any bail prohibits them from being released. So they felt like it discriminated against, poorer people because they couldn't come up with the $200. Even though that wasn't excessive, they didn't have that option. So the lower class, um, you know, were stuck sitting in jail awaiting trial while people with more money could be released. And we found that that kind of was discriminatory practice. So they started trying to look for people who really weren't a flight risk and would show up for court but just didn't have the money. This led to the development of supervised pretrial release. And this was another way that people who were considered low risk could be released on their own recognizance so long as they had some form of supervision. It was almost like probation before you go to court. You still have to report in, check in, those type things. Something that comes into play here is the plea bargain. And a plea bargain, you can plea out for a couple of different things. One, you could plea for a reduced sentence. That's less punishment. Um, you could also plea out for a less, either a less serious crime or a less serious sentence. Like, okay, I'll plead guilty to murder if you won't seek the death penalty. Or I'll plead guilty to aggravated assault, or I'll plead guilty to simple assault instead of aggravated assault or battery, or however they want to negotiate that. That really comes into play with three strikes laws. If this would be your third strike with an offense, you might be willing to plead to a different charge. It's beneficial to us in that it saves taxpayers money, it saves us court time. The DA loves it because they're of course elected and they really focus on their conviction rate. It's very important to them that they not lose cases when they go to court. And so they may feel like they don't have enough evidence to get a conviction, but we know the person, like we feel like this person's guilty, so we'll offer a plea bargain. We get the conviction, they get punished, and it's kind of a win-win situation, unless you're the officer working the case. And then it's very frustrating when you've worked really hard and you feel like you have the evidence and they're just letting this person walk for a lesser charge. That can be really frustrating. But we look at what's best kind of through the overall system. This brings us to the pre-sentence investigation. This is our PSI, and it's a critical tool for judges in the sentencing process. It's a report on the offender. It gives the background, including criminal background, social background, education, employment, mental health, all of these important issues. Does the person have a job? Do they have ties to the community? All of these things can come into play. It's usually prepared by a probation officer that works for the court. It serves 5 major purposes. 1 is for use of the court by sentencing. 2 is for use in determining supervision needs during probation. Can they go into a high caseload or do they need to go into a low caseload? Do they need to report, weekly or, quarterly? All of those factors come in. The third one is for use by prison officials in classifying offenders and determining their program needs. So when a person is being sent to prison, where do we house them? What type of offenders do we put them with? Do they need counseling? Do they need drug treatment? What programs do we need to offer for them? The fourth one is for use by the parole board in making release decisions. When is this person eligible for parole? And then the fifth one is we're criminologists. We need it for research purposes. We want to look at the types of offenders and their backgrounds and how that plays. So through all of that, we come to sentencing. And there are 6 major sentencing options. One is economic sanctions, and that's fines and restitution. It could also be community service. And this is where we're going to hit the pocketbook, hit you in the wallet. It's going to have a big impact. The second one is probation. This is a suspended prison sentence. Basically, if the offender agrees to meet certain regulations and they don't get in any more trouble, they can remain in society and, be responsible for their own actions. Then we have intermediate sanctions. Anything that falls between probation and prison would be an intermediate sanction. Things like house arrest, boot camps, halfway houses, all of these could fall in there. Then we have short-term confinement, which is a sentence of 1 year or less. That's usually served in a jail. And then imprisonment, which would be a sentence of more than 1 year. It's usually served in a prison. That's not always the case. We have plenty of people who spend years in jail and plenty of people who get out of prison in less than a year. And we'll talk about that more as we go. The final one is capital punishment, which is, of course, our death penalty. We still execute in several different ways here in the United States. Still legal in the United States would be, of course, lethal injection, the gas chamber, the electric chair. We still hang in the United States. Interesting side note, you can't hang somebody if they are morbidly obese, because that's cruel and unusual punishment, because that will decapitate them. Any state that has hanging must have a secondary method. And the fifth method that we still use is firing squad. And every state that still uses firing squad does have an alternative method there as well. Sentences can be served in two different ways. We have concurrent sentences where they're served at the same time. So you get busted for armed robbery, and you get 3 years for one and 5 years for another. Then what they say is you serve them at the same time. So at the same time you're doing the 3 years, you're doing the 5 years. So the maximum that you would get would be that 5 years. So they're both satisfied. Consecutive sentences would be one right after the other. So when you complete that 3 year sentence, then you start your 5 year sentence. A lot of people ask me, what is the point in having 57 consecutive life sentences when we're talking about, like serial or mass murderers? Why do they do that? Well, a life sentence in most states is 20 years. And you could be eligible for parole at a certain time. Well, when we make consecutive life sentences, it means as soon as you're eligible for parole and they grant it, you start the next sentence. And it's how we can truly guarantee life imprisonment. I know we're going to talk about the death penalty later on. A lot of people have a lot of strong opinions on this. And, there are a lot of factors that come into play. My personal belief is that there are some people who just should not be allowed to go on living. However, I don't believe that the death penalty is effective. It does not deter people from committing crime. We've done lots of studies on that and found that when someone is committing an offense, they're not worried about getting the death penalty. It doesn't deter crime. They're worried about getting caught, but not the punishment afterwards. So it doesn't really serve that purpose. And the death penalty is much more expensive than life in prison. And I know that sounds crazy. I mean, I've thought many times, like, come on, it can't be that expensive for these drugs, or bullets are cheap, a rope is cheap. It can't be that expensive. But it's actually the legal process, the appeals process that goes with that. And I think it's really important that we keep that appeals process. If you've ever had a chance to look at Project Innocence, they work with people they believe are factually innocent. Not legally innocent, as in, evidence shouldn't have been admitted, or a lawyer did something wrong where they should have been found legally innocent, not because they didn't do it, but because there was a problem with court. They look at factual innocence, people they truly believe didn't commit the crime. And there are a lot of people that they get out of prison every year because it turns out they really didn't commit the crime. Certainly, they were booming when DNA evidence became more admissible and more available. And because of that, I feel like we do need the appeals process. We've had lots of people who we do find out as time goes by that they really didn't commit the crime. So there has to be that waiting period. I know some states Texas in particular, has a policy that if there are more than 3 eyewitnesses to whatever you did, they can eliminate some of the appeals and expedite that process. My problem with that is that eyewitness testimony is really, really unreliable. And we'll talk about that. But so that's one of the issues with the death penalty. We have two types of sentencing models. One is indeterminate and the other is determinate. Indeterminate sentencing, they basically have a minimum and a maximum sentence, so not less than 2 years nor more than 7 years. The actual time that a person serves is up to the release authority, the parole board, and they determine when this person should be released. They haven't gotten in any trouble, they've completed, these different rehabilitation programs, counseling, anything like that can come into play. The second method is determinate sentencing, and this is a sentence of a fixed term, no early release. You did the crime, now you have to do the time. And that's really where we've moved to in recent history is determinate sentencing, and that's that fixed term. A lot of people were upset that offenders were being released early. You sentenced them for 6 years and they did one and got released. So we moved to that determinate sentencing. One aspect of that is truth in sentencing legislation, and it requires an offender to serve 85% of the sentence before they're eligible for parole. And that's kind of trying to find that balance. Interesting thing about determinate sentencing, which is where we've moved, the idea was that offenders would serve more time. Well, what's actually happened is violent offenders, whereas the parole board used to keep them longer and say, nope, we're not willing to release them, they're not safe for society, and the parole board wouldn't grant them parole, they would serve longer sentences. Well, under determinate sentencing, violent offenders are actually serving less time than they did before, but non-violent offenders are serving much longer sentences. And that really comes into play because I don't know about you, but I'd rather violent offenders serve more time and nonviolent offenders serve less time. If I have to choose between my car being broken into and being shot, I'm definitely going to pick my car being broken into. I'm definitely going to go the nonviolent way. So it hasn't actually worked the way people think it would. But a lot of people aren't aware of that. And so there's still this push for longer sentences, truth in sentencing. And nonviolent offenders are looking at much longer sentences. There's a couple of ways that sentencing has been limited, and that's through mandatory minimums. There has to be a minimum sentence for certain crimes. 3 strikes laws, which is the really long prison sentence for the third offense, and presumptive sentencing, which is a predetermined range of a sentence, allowing the judge to determine if there are mitigating or aggravating circumstances. Basically, it's, okay, you have to pick a sentence within this period, but you can look at what else was going on. Maybe you feel this person deserves a smaller sentence than maybe someone else. And then sentencing guidelines, which combine the mandatory and presumptive approaches. So that gets us through kind of the basics, how we get to sentencing, how it's evolved, where we are now. In our next unit, we're going to look at a lot of different topics. It's a bigger unit, and I look forward to talking to you then.